You are being threatened with imprisonment for not paying a tax on something you don't even use. Let that sink in. The South African government, through the SABC, is sending you letters threatening legal action, blacklisting you at credit bureaus, and even criminal prosecution, all because you have not paid for a television license. But here is the question they do not want you to ask. On what legal authority is this being done? Because when you actually open the law books and read the Constitution, when you look at the Broadcasting Act of 1999 and the Electronic Communications Act of 2005, you quickly realize that the entire television license regime is built on a legal foundation about as solid as a sandcastle at high tide, and the people threatening you with jail time know it. The Constitution of South Africa is the supreme law of the land. Section 2 makes that crystal clear. Any law or conduct inconsistent with the Constitution is invalid. That is not a suggestion. That is a hard, unbreakable rule. If any law violates the Constitution, that law is dead on arrival. And when you look at the television license regime, what it does and how it operates, you will find violation after violation that should have seen this entire scheme struck down decades ago. Consider Section 192 of the Constitution. It states that national legislation must establish an independent authority to regulate broadcasting in the public interest and to ensure fairness and a diversity of views broadly representing South African society. Note those words carefully. In the public interest. Not in the interest of the SABC, not in the interest of a state-owned enterprise, not in the interest of a commercial entity operating under the Companies Act. The public interest. Broadcasting is supposed to serve the people, not the other way around. Yet here we are, with citizens being threatened with fines and imprisonment for not paying for a service that is supposed to serve them. How exactly is that in the public interest? Now let us look at the Broadcasting Act of 1999. Section 27 creates the television license obligation. It states that no person may use any television set unless they are in possession of a television license issued by the corporation against payment of the prescribed fee. On its face, that seems straightforward enough. But what does the Act define as use? The definition in Section 1 says that use means the use or possession of a television set or permitting any other person to use or possess a television set. That is chillingly broad. It means that if you own a television set that is not even plugged in, if you have a television set that is broken and cannot receive any signal, if you have a television that you only use for watching DVDs or playing video games, you are still obligated to pay the license fee. Because the law criminalizes mere possession. You can be charged with a criminal offense, you can face a fine of up to 500 rand per offense, or imprisonment for up to 6 months, simply for owning a television set. Not for using it, not for watching SABC, not for receiving any broadcast, but simply for having it in your home. That is not regulation, that is extortion dressed in legal clothing. Section 27(5) makes it crystal clear. Any person who contravenes any provision of this section is guilty of an offence and liable upon conviction to a fine not exceeding 500 rand in relation to each such offence or to imprisonment for a period not exceeding 6 months or to both. So the state has criminalized the mere possession of a television set. And for what purpose? To fund a public broadcasting service that most South Africans do not even watch. Let us talk about the reality of broadcasting in South Africa today. According to the Broadcast Research Council, television penetration in South African households is over 90%. That is millions upon millions of television sets. Yet the number of people actually paying television licenses is a fraction of that. The SABC openly admits that license fee compliance is abysmal, with estimates suggesting that only around 30% of households pay their license fees. That means more than 2/3 of South African households are in violation of this law. The government has created a law that the vast majority of its citizens cannot or will not comply with. They have created a law that is practically unenforceable, and they know it. That is why they send threatening letters. That is why they outsource debt collection to private companies. because they cannot actually prosecute everyone. There are simply too many of us. The law has become a tool of harassment, not a mechanism of governance. So why are so many people not paying? The answer is simple, and it is one the SABC and the government do not want you to hear. Most people do not watch the SABC. South Africans have moved on. We are a nation of cord cutters. We are binge-watching on Netflix, consuming content on YouTube Premium, subscribing to Showmax, watching DSTV, streaming on Amazon Prime. People are paying for the content they actually watch, and they are refusing to pay a tax on a service they do not use. And why should they? This is a fundamental question of fairness. Why should you be forced to pay for a service you do not consume, especially when the money goes to a state-owned enterprise run by political appointees and repeatedly shown to be financially mismanaged? Section 10 of the Broadcasting Act outlines the public service the corporation must provide. It must make services available in all official languages, reflect the diverse cultural and multilingual nature of South Africa, provide significant news and public affairs programming, include educational programming, and so on. These are noble goals. But the reality is that the SABC has consistently failed to deliver on these obligations. Their viewership has been declining for years. Younger audiences have abandoned the broadcaster. Yet the SABC continues to demand payment, continues to harass South Africans, continues to threaten legal action, all while failing to deliver the service that the law requires of them. And who is supposed to be collecting these fees? The Act says the corporation may issue television licenses. It says the corporation may appoint authorized inspectors. The corporation is the SABC, a public company in terms of the Companies Act, with the state as its sole shareholder. That means the SABC is both the service provider and the tax collector. They are the judge, the jury, and the executioner. They decide what you owe. They send you the bills. They send you the threatening letters. They appoint inspectors who can enter your property and demand to see your television. But where is ICASA in all of this? The Independent Communications Authority of South Africa was established to be the independent regulator. Yet the television license regime sits outside their oversight. The SABC collects the fees, the SABC keeps the money, and the SABC threatens the citizens. This is not regulation, this is a shakedown. Section 27(8) states that all television license fees collected by the corporation must be used by the corporation solely for the public service to be provided by the corporation, not for the Department of Communications, not for ICASA, not for any other government function. The money goes directly to the SABC. And where does it go? Into a company that owns one of the most valuable broadcasting assets in the country, the broadcast rights to major sporting events, and still cannot make ends meet. The SABC is a state-owned enterprise. It is a commercial entity that sells advertising and sponsorship, yet it demands a tax from the public to subsidize its operations. This is a direct subsidy to a commercial entity, a hidden tax on the public that serves no legitimate public purpose. Now, let us talk about the constitutional implications. Section 12 guarantees every person the right to freedom and security of the person, which includes the right not to be deprived of freedom arbitrarily or without just cause. Yet the Broadcasting Act allows for imprisonment for not holding a television license. You can be thrown in jail for not paying what is essentially a tax on a piece of equipment. Is that proportionate? Is it fair, reasonable, justifiable in an open and democratic society? Section 36 says rights may only be limited to the extent that the limitation is reasonable and justifiable. The television license regime limits multiple constitutional rights. It limits the right to freedom and security, the right to privacy, the right to property, the right to freedom of movement because you cannot cancel the license when you move, the right to access to information because the government is supposed to provide information but instead criminalizes those who do not pay for it. Section 14 guarantees the right to privacy, which includes the right not to have their person or home searched, their property searched, their possessions seized, or the privacy of their communications infringed. Yet the Broadcasting Act allows authorized inspectors to enter upon any land, including residences, and demand to inspect television sets. This is a gross violation of privacy. The Act does not require a warrant for many of these inspections. During daylight hours, an inspector can simply show up at your home, demand to inspect your television, and require you to produce your license. This is a violation of the principle of legality itself. Section 9 guarantees equality before the law. The television license applies to anyone who owns or possesses a television set. But the government does not equally enforce this law. They cannot. There are too many violators. So they pick and choose, targeting those who are easy to find, those who register for other services, those who are vulnerable. This is arbitrary and selective enforcement, a form of discrimination. The law is applied unequally, and that is a violation of the constitutional guarantee of equality. Section 29 guarantees the right to education. The SABC claims license fees fund educational programming. But education is a constitutional right. The state has a constitutional obligation to provide education. They cannot turn around and say that in order to exercise that right, you must pay a license fee. That is double taxation. You already pay taxes to the state, which is supposed to fund education. You cannot be forced to pay an additional fee for a service the state is constitutionally obliged to provide. Section 32 guarantees the right to access to information. The state has a duty to provide information to the public. The SABC is a state-owned broadcaster, part of the state apparatus. Yet the state criminalizes you if you do not pay for the apparatus through which it provides information. The contradiction is staggering, the hypocrisy breathtaking. The state is actively harming citizens for exercising their constitutional rights, or more accurately, for not paying a tax to exercise those rights. The government is supposed to be providing information because the people have a right to it. Instead, the government is threatening people with fines and imprisonment for something it is responsible for providing. How absurdly contradictory is that? And what about freedom of expression under Section 16? This includes freedom of the press and other media, freedom to receive or impart information or ideas. The SABC, as a broadcaster, is supposed to facilitate this right, but by making access to broadcasting subject to a license fee, the state is effectively putting a tax on the exercise of the right to receive information. They are creating a barrier to the exercise of a constitutional right. The SABC is a public state-owned institution. It should be funded by tax, not licenses. That is the fundamental point. The government already collects taxes from us. VAT, income tax, fuel levy, excise duties all go into the National Revenue Fund. The SABC should be funded from that fund. Instead, they have created a separate, parallel system of taxation that applies to a specific group of people, television owners, and which is collected by a private company owned by the state. This is bad policy. But it is also bad law. And let's talk about cancellation. If you decide you no longer want a television, if you give it away, if it breaks, you still have to pay the license fee unless you formally cancel it. And how do you cancel it? You have to provide proof that you no longer have the television. You have to fill out forms, provide affidavits. The process is so burdensome that many people simply give up and continue paying. And if you don't, they continue sending threatening letters. This is not just a tax, this is a trap. You can't simply stop paying, you have to go through an administrative process designed to be as difficult as possible. And if you move, the license follows you. You can't cancel it even if you move into a new home and don't bring the television with you. The license is attached to the person, not to the television. The Electronic Communications Act of 2005 was supposed to bring convergence. Section 94 says that in the event of any conflict between the provisions of the Electronic Communications Act and any other law relating to broadcasting or electronic communications, the provisions of the Electronic Communications Act prevail. That means if there is a conflict between the Broadcasting Act and the Electronic Communications Act, the Electronic Communications Act wins. And what does the Electronic Communications Act say about broadcasting services? It defines them, it regulates them, it provides for licensing. But nowhere does it authorize the SABC to impose a tax on television sets. The Electronic Communications Act's object is to promote the universal provision of electronic communications networks and services and connectivity for all. The television license regime does the exact opposite. It creates a barrier to universal access. The SABC has outsourced debt collection to private companies. These companies send threatening letters, they phone you, they demand payment. They threaten to blacklist you at credit bureaus. But is this legal? Section 27 empowers the corporation to collect fees and penalties, but it does not explicitly authorize outsourcing to third parties. And even if it did, the actions of these debt collectors are often illegal. They are harassing people, demanding payment for debts that may be prescribed or invalid, making threats that are disproportionate. All of this is being done on behalf of a state-owned company, which means the state is ultimately responsible. I am calling on every South African to challenge the legality of the television license in court. We need a declaratory order that Section 27 of the Broadcasting Act is unconstitutional. We need a court to say the state cannot criminalize the possession of a television set. We need a court to say the SABC cannot levy a tax on the public. If one person brings a challenge and wins, the entire system will collapse, the floodgates will open. The SABC will be forced to find another way to fund itself. The legal arguments are strong. The constitutional violations are clear. The practical considerations are overwhelming. This law is unworkable, unfair, unjust. It has no place in a modern democratic South Africa. It is time to end it. So the next time you receive a threatening letter, remember this. You are not the criminal. They are. They are violating your constitutional rights, harassing you, threatening you with imprisonment for a tax that has no legal basis. You are under no obligation to pay. You have the right to challenge them. You have the right to refuse. And to those already paying, why are you still paying? What are you getting for your money? A service that is underperforming, underfunded, overrun with political appointees. A service you don't even use. A service the state has a constitutional obligation to provide to you for free. You are paying for nothing. It is time to take a stand. It is time to say no. It is time to challenge this illegal, unconstitutional tax. Go to court, file an application, join a class action, write to your MP, write to the Minister of Communications, demand that this law be repealed. We must exercise our rights. We must not allow the government to bully us into paying a tax we never agreed to. The television license is dead. We just need to bury it. The government of South Africa has a duty to its citizens. That duty includes providing access to information, to education, to entertainment, all the things a public broadcaster is supposed to provide. But that duty cannot be discharged by imposing a tax enforced through threats of imprisonment and debt collection. That is not governance, that is oppression, and we will not stand for it. This is a battle for the soul of our democracy. This is a battle about whether the government serves the people or the people serve the government. This is a battle about whether the state can use the criminal law to enforce a tax that is nothing more than a subsidy to a commercial entity. We will not allow it. We will fight back. We will challenge this law, and we will win. I want you to imagine a South Africa where you are not constantly harassed by debt collectors, where you can watch whatever you want without being threatened with imprisonment, where the government is accountable to the people, not the other way around. That South Africa is within our reach. We just need to take the first step. We just need to say no. We just need to challenge the law. The Constitution is on our side. We are the majority. We are the people. And we will not be defeated by the intimidation tactics of a state-owned enterprise that cannot even deliver a decent service. Let us reclaim our constitutional rights. Let us reclaim our democracy. Let us reclaim our freedom. We will not be silenced. We will not be cowed. We will not be bullied. Not now, not ever. The television license is a relic of the past. It has no place in our future. It is time for it to go, and we are the ones who will make it go.